Alright, Ohio Laws, Administrative Rules, Chapter 1509, Division Oil, Gas, Resource Management, Oil and Gas. We're on 1509.8. Terminations of well in coal bearing township. Upon receipt of the application for the permit requiring 1509.05 of the revised code, upon the receipt application permit to plug and abandon under section 1509.13 revised code, Chief of the Division Oil Gas Resource Management should determine whether the well is to be located with a coal-bearing township. Whether or not the well is to be located with a coal-bearing township, Chief of the order may refuse to issue a permit requiring Section 1509.05 of the revised casual application time of the applying with the permit. The material of the substantial violation of this chapter rules adopted or ordered issuing with the under the Chief of the refuse with the issue with the applicant with the issue permanent with the applicant with the time of the applying with the permit to the final but liable with the non-appealable order of the court competent jurisdiction damage of the streets, roads, highway, bridges, and culverts, drainways, pursuant to Section 45.13.34 and 55.77 and 12 revised code of the applicant provides the chief of the applicant's compliance with the order. No applicant shall attempt to circumvent the provisions applying for the permit under the different name of the business organization and transferring the responsibility to another person and either the abandoning of the well or leasing or by any other similar action. Similar act. If the well is not or is not to be located with a coal-bearing township, if it's located with a coal-bearing township, the landowner submits the affidavit of testing with the ownership of the property and fees, simple, including coal with a non-objective well. The chief is issued with a permit. If the applicant drilled the reopen and convert the concern of the well is issued located with a coal-bearing township, the chief shall transfer to the chief of the division minerals resource with the management the 2 copies of the application and 3 copies of the required Section 1509 revised code, except that with the affidavit of wavering objection described above is submitted with the Chief of the Division of Oil, Gas, Resource Management, transfer with a copy of the Chief of the Division of Mineral Resource Management. Immediately notify the owner and leaser effective with the applicant with the has been involved with the sum of the owner and leaser with 2 copies of the map of the company with the applicant set forth at the location of the well. If the owner and leaser object to the location of the well, objects to any location within 50 feet of the original location as possible site with relocation well, if the owner or leaser notify with the Chief of the Division of the Mineral Resource Management objection, give them a reason for the objection. If the applicant will indicate with a copy of the map of the particular location 50 feet with the original location of the owner and leaser objects as site with a possible relocation of the well 6 days after the receipt of the notice, the chief of the recovery receive of the no objection for the owner and leaser of the mine within 10 days of the receipt of the notice of the owner and leaser. If the option of the chief of the objections offered by the owner and leaser are not sufficiently well founded, the chief of the immediately shall notify the owner and leaser of those findings. The owner and leaser may appeal with the division may appeal with the decision of the chief of the reclamation of the commission of 1513.13 revised code. The appeal shall be filed within 15 days with not with provisions without standing provisions of A1 of Section 1513.13 revised code contrary of the day of which the owner will release of the receipt of the notice of appeal will not filed by the time of the chief of the immediately shall approve of the application, retain copy of the application, and map returning copy of the applicant with the chief of the division of the oil and gas resource management approve of the noted on it. The chief of the division of oil resource management shall issue a permit if the provision of the chapter pertaining to the issue of such permit has not complied with. If the chief of the division mineral resource management receive the objection of the owner and leaser of the mine is the location of the well within 10 days of the receipt of the notice, owner and leaser of the opinion of the chief of the objection of the well is found, the chief shall disapprove of the application immediately return the chief of the division of oil gas resource management together with the reason of the disapproval of the suggestions for the new location of the well, provided the suggested new location should not be on location of 50 feet of the original location to which the owner and leaser have objected site with the possible relocation of the well. Chief of the division of the mineral resource management determined with the objection as well with the found with the chief of the division of oil resource gas resource management immediately shall notify applicant to permit with the disapproval of any of the suggestion made with the chief of the division mineral resource management new location of the well. Applicant withdraw with the applicant with the append with the applicant with the drill with the location with the suggestion chief of the applicant appeal with the disapproval of the application chief of the reclamation commission. If the chief of the division of mineral resource of the management receive the no objection of the owner and leaser management for the location of the well, but it doesn't receive the objection of the owner and leaser for the one more location 50 feet with the original location as possible sites of relocation of the well 10 days after the receipt of the notice of the owner and leaser for the opinion site of the direction of the well found with the nevertheless approval of the application shall be returned immediately with the chief of the division of oil gas resource with the reason for the resource management shall issue the permit provisions of the training chapter pertaining to the issuance of the permits have complied with the incorporating term and the conditions of the permit applicable to prohibited with the commencing with the drilling any location 50 feet of the original location with the disapproved by the division of the mineral resource management. Applicant may appeal with the Reclamation Commission over the term and condition permitting prohibition of the commencing of the drilling and such disapprove of the chief of the division of mineral resource management. and such appeal will be filed within 15 days, notwithstanding the standing provisions the A1 of Section 15.13.13 Revision Code of the contrary with the day of the application receipt of the notification, disapproval of the application and location 50 feet of the original location, term of the condition, permit, and the owner of the lease will receive the notification. Chief of the division of the non-approval or disapproval of the application shall delay with the chief of the division of the mineral resource management for more than 15 days of the date sending with the notice of the application of the minor and leaser are required by this section. All appeals of the section shall be treated as expedited appeal. The reclamation shall be heard of the appeal within accordance in Section 15.13.13 Revised Code of the decision 13 days after the filing notice of the appeal. Chief of the division of the oil and gas resource management shall not issue the drill of the new well or reopen a well that has not been located within 300 feet with any opening with a mine with a means of ingress, egress, ventilation of the person of the employee with the time no one nor within 100 feet in building inflammable structure with the connected with the mining of the actual use of the operating equipment of the mine. The chief of the division of the mineral resource management determines the life of the property and danger of the drilling of the operation of the well is located. Chief of the division of the mineral resource management will suspend the drilling and the reopening of the well of the coal-bearing township with the determining that the drilling and reopening activity present with the imminent substantial threat of the public and safety, miners' health and safety, and have been enabled to contact the chief of the division of the oil and gas resource management to request an order of suspension, section 1509.06 Revised Code. Before the issuing the suspension order, the purpose of the chief of the division mineral resource management shall notify the owners in the manner with the chief of the judgment with a provide reasonable notification. Chief that intends for there to be issues a suspension order. The chief may issue the order with a written notification responsible to attempt to notify whether the owner had failed with the event, with the notification is given thereafter practicable. Within 5 calendar days of the issuance order, the chief may provide with the owner of the operator to be heard with the president if the activity does not present imminent and substantial threat to the public health or safety of the miner's health or safety, and if they're considering the evidence present with the owner, the chief determines if the activity do not present such a threat, shall revoke the suspension order, and may appeal the suspension order issued by the chief of the division of mineral resources under the section of the Reclamation Commission in accordance with 1513 in Revised Code, and may appeal for the order directly to the court of the county and pleas of the county in which the well is located. Changing the location of well after issue with a permit. A well may be drilled under a permanent location for the designated with a map within the section 1509. So the location of the well may be changed after the issue with a permit only with approval of the chief of the division of oil gas resource management. And if the well is in coal-bearing township with approval of the chief of the division of the mineral resource management under procedures under section 150908 Revised Code with a permit with the drill and unless the permit holder requests issuing with emergency drilling permit under such section due to loss over the under circumstances for the completion of the well is not feasible original location. If the permit holder requests a change of location, permit holder should return with the original permit and file an amended map indicating the proposed new location during drilling should not be commenced with a new location original permit and notating the approval by chief of the proposed at the well site with however the permit holder may be the drill with a new location for the receiving the prior approval by this section if all of the following conditions are met within one working day after suspending a new well with the permit holder filed with the request emergency drilling permit submits to chief of the division oil gas resource manager applicant the permit that meets requirements section 1509.6 for review and prove the permit required that the section of the amended map show the new location oil and gas resource inspector for the present of the spudding operations are commenced at that location. Original well is plugged prior to the skidding of the drilling of the rigging to the new location. Plugging is witnessed and verified with the oil gas resource inspector of the well is located in the coal-bearing township about the deputy of the minor inspector oil gas resource inspector under the chief of the chief and authorized representative to temporarily waive the requirement, but in the event of the original well shall be plugged before the drilling the rig is moved from the location. New location is 50 feet with the original location left upon the request of the permit holder, the chief of the approval of the chief of the division with the mineral resource management located with the coal-bearing township. Bearing Township agree with the new location farther than 50 feet with the original location of the new location, all of the distance of the space and requirements specified with the rules adopted in section 1509.23 and 1509.24 Revised Code. If the well is located in the coal-bearing township, the chief of the new location, however, the disapprove of the chief of the division mineral resource of the management has not been prohibited, term and condition permanent under section 1509.08 Revised Code. If the chief of the division of the oil gas resource management approve of the change of the location, chief of the issue of the emergency permit with the 2 working days after the filing of the request for the emergency permit, the chief of the disapprove of the change of the location of the chief by order deny the request or may issue of the appropriate enforcement under section 1509.03 of the revised code. well to be logged with well logged to be filed with the division contents form. The person who's drilling with the well shall state with the shell within 60 days after the completion of the drilling of the operation of the depth of the after the determination well with the dry the last hole the file with the division oil gas resource management over the wire electronic logs accurately well completion of the record of the form of the prescribed of the chief of division oil gas management resource management that designates purpose of the well which was drilled with the chapter of the depth of the thickness of the geological unit encountered including coal seams, mineral beds, associated fluids such as fresh water, brine, and crude oil, natural gas, or sour gas, such as seams, beds, fluids, and gases are known. Dates on which the drilling operation will commence and completed with the type of the drilling tools used with the name of the person of the drill of the well, the length of the fact of the various casing, such as the casing tube and the the drilling of the well with the amount removed after the completion, with the type of the depth of each of the pack of all the relating commencement, cementing with the annular space behind the casing of the tube and the date with indicating the completion of the dry gas oil combination, oil gas brine injection, artificial brine well, and stratigraphic test. Number of preparations, casing interval for preparation, elevation above main sea level, the point of the depth of the measurement of the made stating height of the point above the ground at the well for the whole depth of the well, the deepest geological unit with the penetrative of the drilling of the well, F applicable the type of the volume concentration of the acid, date of the acid, which acidizing the well. If applicable, the trade name of the total amount of all of the product fluids and substance of the supply of each of the product fluid and substance with not including cement with the constant with the lowest of the circulation material with the intentionally additive soil of the drilling any of the portion of the well until the surface of the casing is set with the proper seal of the owner should identify with the additive of the material with the used to provide with a brief description and purpose of the additive used. In addition, owner shall include a list of all the chemical with not including the information designated with the trade secret pursuant with the division I-1 of this section, essentially added to all of the product fluids and the substance with included in the chemical correspond with the chemical abstract service number, the maximum concentration of each of the chemical with the owner shall obtain with the chemical information, including the information designated with the trade secret for the pursuant with the division 8-1 I-1 of the section of the company drill over the well provided services of the well supplied with the chemical for the company drill over the well provided services over the well supplied with the chemical provided incomplete, inaccurate chemical information. The owner shall make a reasonable effort to obtain the required information for the company or supplier for the purpose of the division A9A of the section of the recycled fluid. You the total volume recycled fluid with the well with the source of the recycled fluid and centralized facility with the source of the recycled fluid. 10A. If applicable, the type of the volume fluid, including the cement with the constitute of the information designated with the trade secret for the pursuit of the division I-1 of the section stimulated with the reservoir with the well reservoir breakdown pressure method. You would contaminate the fluid, recover the fracturing of the well with the method. You would contaminate the fluids when pulled with a well bore, swabbing the well with the average of the pumping rate of the well. The name of the person performed of the well stimulation in addition of the and should include with a copy of the log from the stimulation over the well, the copy of the invoice of each of the producer of the methods of the described in division A10 of the section that were used in the well. A, the copy of the pumping the pressure of the rate graph, how the owner may rate the copy of the each invoice required to included the subdivision A10 of the section of the cost and changes in charge of the procedures method described in A10 of the section that were used on the well. If applicable, with the trade, the name of the total volume of all of the product and fluid, substance of the supply of each of the product with the fluid and substance of the used with the stimulate with the well, with the owner shall identify with the additive used with the provided a brief description of the purpose of the additive used include some concentration of the additive additional with the owner shall enlist with all of the chemicals not included in the information designated with the trade secret pursuant with the division I-1 of the section intentionally added to all of the product and fluids and substance of each of the chemical corresponding with the chemical abstract with the number of the maximum concentration of each component chemical with the owner shall obtain with the chemical information not included in any of the information designated with the trade secret pursuant with the division I-1 of the section of the company stimulated well supplied with the chemical with the company stimulated with the well supplied chemically provided the incomplete inaccurate chemical information. The owner should make a reasonable effort to obtain with the required information on the company for the supplier. For the purpose of the division A10B with the section of the recycled fluid was the total volume recycled fluid was well with the source of the recycled fluid and centralized facility in the source of the recycled fluid. The name of the company performing the logging of the well and the type of the wireline electrical logs performed on the well with a well completion record submitted with a duplicate of the first copy to obtain retained with a permanent record with a file of the division with the second copy of the made transmit with the chief of the division of the geological survey no later than 60 days after the completion of the drilling operation prepared with the total depth of the owner shall file with all wireline electric logs within the division oil gas resource management chief of the oil transmit with such joint logs electronically if available. The division geological survey such logs may be retained by the owner a period of not more than 6 months for the test of additional times may be with the granting of the chief of the writing and after completion of the substantial of the depth of the shown with the applicant required by section 150906 revised code. If the well is not complete within 6 days, if after the completion of drilling operation, the owner shall have the file of the division of oil gas resource for the management supplemental well completion record that include the information required with the section 60 days after the completion of the well. After a well that initially completed with the stimulated with until the well is plugged, with the owner shall report on a form prescribed by the chief with all the materials placed in the formation of the refractor re-stimulated and renewally complete with the well. The owner shall submit the information 60 days after the completing of the reef manufacture re-stimulation of the new completion of the addition of the owner shall report with the information required in subdivision A10, A8, or to C of the section of the applicable with the manner of the consistent with the requirements established in this section. C. Upon request of the rating with the chief of the division of the geological surveyor prior to the beginning of the drilling of the well, the person drilling the well shall make a complete set of the cuttings accurately identified with its depth. D. The form of the well completing the record required for the section shall be one with the prescribed chief of the division, oil gas resource of the management, chief of the division, geological survey filing of the log is required for the section fulfilled for the requirement of filing of the log of the chief of the division, geological survey in section 1505.04 revised code. If the material listed is designated A9, 10, or B3 of the section of the material of the division, oil, gas, resource management does not have the material safety data sheet, the owner shall provide with a copy of the material safety data sheet with the material to the chief. Owner of the submit the chief of the information required of the division A10, B, and C, and B3 of the section inconsistent requirements shall establish in this section one of the following methods. On the form prescribed by the chief through the chemical disclosure register of the maintained with the Groundwater Protection Council of the Interstate Oil, Gas, and Compact Commission, any other means approved by the chief of the post of the division website, each of the material safety data sheet to obtain within under subdivision E. The section additional chief shall make it available the division website with the chemical information required in subdivisions A9, A10, and B3 of this section. H1. If the medical professional, in order to assist the diagnosis treatment of the individual who is affected with the incident associated with the production of the operation of the well, requests exact chemical composition, each of the product fluid substance of each of the component of the product of the fluid substance of the designated with the trade secret pursuant of the subdivision I. The person claiming with the trade secret protection pursuant with the division shall provide with a medical professional with the exact chemical composition, product, and fluid substance of the chemical component and product of fluid of the substance that is required. 2. If the medical professional receives the information pursuant to the division H1 of the section shall keep the information confidential, does not discover the information purpose of the not related to the diagnosed stream of the individual who is affected with the incident associated with the production operation of the well. Nothing within the division H2 of the section precludes medical professionals from making any report required by law or professional ethical standard. I-1. The owner of the well who is required to submit with a well completion record under subdivision A of the section of the report under B3 of the section of the person provides information owner to describe the purpose of the division A9 or 10 or B3 of this section designated without disclosing and the perform the described chief with the whole of the disclosure of the identity and with the amount with the concentration purpose of the product of the fluid of the substance of the chemical component of the product of the fluid substance of the trade secret. Owner and person may pursue the enforcement of the rights of the remedy established in section 1333.61 and 1333.69 of the revised code of the misappropriation defined in section 1333.61 of the revised code with respect to the identity amount of the concentration purpose of the product, fluid, and substance, chemical component of the product and fluid of the substance designated by the trade secret pursuant of the division I-1 of the section of the division shall not discover the information regarding the identity of the amount of the concentration purpose of any of the product and fluid of the substance of any of the component in the product of fluid of the substance of the designated with the trade secret of the pursuant division I-1 of this section. 2. For the property owner with adjacent the property owner with any person, agency, state having an interest of the being adversely affected with the product of the fluid, the substance of the chemical component in the product of fluid of the substance in the commerce, the civil action court with the common pleas with the Franklin County against any owner or person described in the division I-1 of the section challenging with the owner and the personal claim of the entitlement of the trade secret protection from the specific identity of the amount of the concentration purpose of the product and fluid and substance of the chemical component in the product and substance pursuant with the division I-1 of the section. Person may commence with civil action pursuant with the division I-2 of this section, provided notice of the chief of the man with the described chief of the civil action court shall conduct with a camera review of the information submitted by owner or person described in division I-1 of this section to determine the identifiable amount with the concentration purpose of the product, fluid, substance, or chemical component in the product or fluid or substance pursuant with the division I-1 of this section entitled with the trade secret protection. J1, except for the information designated by any of the trade secret pursuant with the division I1 in this section, separately provided in J2 of this section, the owners of the well shall maintain in the records all chemicals placed in the wells for a period of not less than 2 years after the date at which each of the chemical was placed in the well. Chief may inspect the records at any time concerning any such chemical. An owner or person who designated the identified amount with the concentration purpose of the product of the fluid, substance of the chemical component of the product of the fluid, substance of the trade pursuant with the division 1. I1 section maintain the record of each of the such product and fluid substance of the chemical component of the product fluid substance of the period not less than 2 years after the date of each of the product fluid substance root of the chemical product and fluid and substance was placed in the well upon the request of the chief of the owner and person of the applicant shall discover the record chief of the information that is necessary to perform the well spill release investigation. However, the chief does not discover the information that is designated as a trade secret. K1, for the purpose of correcting inaccuracy and completeness in chemical information requirements of Division A9 and A10 and B3 of this section, ownership will be considered the substantial compliance if the owner has reasonable efforts to obtain the required information from the supplier. And 2, for the purpose of reporting under this section, the owner is not required to report chemicals that occur incidentally or in trace account amounts. As you within the section, term of the material safety data should conform in any revision change of the term of the Occupational Safety and Health Administration of the United States Department of Labor. Alright, 1509.11. The treatment of the production of oil gas prime with the owner and any of the well except for the horizontal well of the producer capable of producing oil gas shell with the file with the chief of the division of oil and gas for the resource management on before the 31st day of the March of the statement of production of oil gas last preceding calendar year. Such form as the chief may prescribe the owner may have the owner has more than 100 such wells. The state shall submit with electronic statement of production with a format approved by the chief of the owner and any horizontal well producing capable of producing oil gas shall file with the chief of the 45 days following the closing of each calendar day with a statement of the production of the oil and gas of the brine preceding the calendar quarter in a form of chief prescribed the owner has more than 100 horizontal wells in the state shall submit with electronically statement of production in the format approved by the chief. If the chief shall not discover the information received with the Department of Taxation under Section 15.703.21 Revised Code, statement of production required subdivided by Division A in this section related to the information filed by the chief. Or defective wells and well plugging. No person shall construct operate a well with a cover the damage or permeable shadow of the underground sources of the water, drinking water, services of the land, with the threatens the public health and safety of the environment. No owner shall permit with the well to leak fluids or gases upon the discover the casing of the well, the defect of the well, if it is not adequately constructed, the person over the owns the well, but the responsible for the well shall know for the chief of the division of oil, gas, resource management within 24 hours of the discovery immediately repair with the casing with the correct construction and adequacy plugging and abandoning of the well. When the chief found that the well should be plugged with the chief shall issue an order to the person that owns the well with the responsible for the well to plug with the well with the shall specify the order reasonable time which will comply. No person shall refuse to plug with the well with the time specified with the one ordered with each of the day with the shall well remain unplugged thereafter after constitute a separate offense. Where for the plugging prescribed within the rules adopted in pursuant to 1509-15 with the revised code can be applied with applied and effective with the carrying out with the protection law with the meant to the give of the chief may designate with a different method of plugging. Abandonment report showing the manner of the wells which was plugged. In the case of the oil and gas wells abandoned prior to September 1st, 1978, with the board of the county commissioner of the county of the wells located with the may submit with the elector of the county with the question establishing special funds with the general levy, general bond issue, or other current funds that should be approved with the majority of the elector of the voting upon this question. For the purpose of the plugging of the well, the fund should also be administered by the board. A plugging of the oil and gas well should be under supervision of the chief of the board. Shall let the contracts for the purpose provided with the funds shall not be used for the purpose of plugging oil and gas wells. They were abandoned subsequent to September 1st, 1978. 1509.13 permit to plug abandoned well application except for the otherwise provided in the Division A2 of the second and Division E1 of the 1509.71 revised code that no person shall plug with the abandoned well without having the permit of the due the issue of the chief of the division oil gas resource management. The permit shall be issued for the chief of the in accordance with the chapter shall be valid for the period of 24 months for the date of issue. The holder of the valid permit issued under Section 1509.06 for the revised may receive the approval of the oil gas resource inspector of the plug abandoned the well associated with the permit without obtaining the permit required under under Division A of this section if either of the following apply with the well. A drill with the total depth of the well cannot and will not be completed. Well is the last hole with a dry hole. The permit holder plugging of the well pursuant to Division A2 of this section shall plug with the well within 30 days of the receipt of the approval of the oil and gas resource inspector for the permit and plugging holding well pursuant with Division A2 be given this section shall plug with immediately after determining the well is the last hole with a dry hole in accordance with the rules adopted on this chapter. The applicant with a permanent plug and abandoning shall be filed with many days in advance of the necessary of the oil and gas resource inspector, or if the well is located in a coal-bearing township with the deputy miner inspector, oil gas resource inspector to present with the plugging. The application shall be filed with the chief of the department in the form of the chief prescribed that shall contain the following information: the name and address of the applicant, the signature applicant with the applicant, authorized agent with the authorized agent signs the applicant with the accompanied with a certified copy of appointment as agent, the location of the well, identified section, location, lot number, city, village, township, county, designation, well by name and number, total depth of the well to be plugged with the date amount with the last production over the well, the other information the chief may require. Except the otherwise provided in in Division E2 with the Section 1509-071 revised code of the application, accompanied with a non-refundable fee with the $250 with the unless waived with the oil gas resource inspector, owner of the well, owner authorized representative that shall notify the oil and gas resource inspector with at least 24 hours prior to the commencement of the plugging of the well. No well shall be plugged with abandoned without an oil and with a gas inspector. Resource inspector present on life of the permission has been granted by the chief. The owner and the well will produce the oil gas shall be given them written notice for the same time of the owner and the land open, which the well is located at all the lessers over the receipt of the gas of the well pursuant to an agreement with the well penetrate for the passage of the 100 feet with the excavation working on the mine. The owner and the well shall give the written notice to the owner and the leaser of the mine intention of the abandonment of the well and with the time of when the owner and the well will be prepared commencing plugging. The application of the may file with the request of the chief of the expedited review. Application of the permit to plug when abandoned the well, the chief may refuse to accept the request of the expedited review if the chief of the judgment accepted the request of the prevent the issue with the 21 days filed with the permits over which the applicant filed with under Section 150906 was code or pending additional completion application of the permit with the means of the requirement of the section permitted fee with prescribed by the section applicant with the request, so there will be accompanied with a non-refundable filing fee of $500 unless the chief has ordered of the applicant to plug with abandoned the well when the request is expedited review is filed with the chief shall immediately begin with the process of the application and show the issue of the permit within 7 days of the filing of the request unless the chief of the orders or denied the application. E1. Except for the otherwise provided in the Division E2 of this section, a person undertake with the plugging of the well which permits may have been issued under the section shall obtain insurance bodily injury covers property damage coverage of the amount established in Section 150907 with the revised code of the body pay the damage injury property of the person include the damage causing the plugging of the well. The person may electronically submit with the proof of the insurance chief upon the chief of the request. Division E1 of the section does not apply with the person already required to maintain insurance policy under Section 150907 of the revised code. This section does not apply with the well plugged abandoned in compliance with 157105 revised code. 1509-14 Report of Abandonment Well. Any person who abandons with a written permission has been granted with the chief of the division oil gas resource management abandonment plug with the well with the inspector being present with the supervisor of the plugging shall with the written report of the abandonment over the chief of the report shall be submitted no later than 30 days after the date of the abandonment shall include all the following: the date of the abandonment, the name of the owner and the operative of the well with the time of the abandonment, the post address, officer of the draft of the owner and operative, the location of the well, the township, the county with the name of the owner, with the surface of the owner upon which the well is drilled and the address thereof, the date of the permanent drill, of the date and when the drill, the depth of the well, the depth of the top of the formation which the well was drilled, depth of each seam of the coal drilled through, and if known, detailed report as well of the well plug was given the particular manner in which the coal various forms and nations were plugged with the date of the plugging of the well, including the name of those of the witness plugging of the well. For shall be signed with the owner and operator or agent of the owner and operative of the abandoned of the plug with the well, verified oath of the party that just so signed on the purpose of this section. Oil gas resources inspectors may take knowledge and administer of the oaths of the party signing of the report. Or 1509-15 Rules and Methods of the plugging. When any well is to be abandoned, the first one to be plugged in accordance with the method of plugging and adopted rule by the chief of the division of oil gas resource management. The abandonment report shall be shown in the manner with which the well was plugged. Plugging at the expense of the operator. Mine operator is about with the encounters an orphan well whose existence is detrimental to the mining operation. Mine operator may plug the well at any mine operator's own expense according to the chapter of the rules adopted under it. are disclosure forms of the oil country tubular goods. Is used within the section oil country tubular goods or means circular steel pipes that seems well with the use of the drilling oil and natural gas, include the casing of the tube with the drill pipe, the instrument, unfinished steel coupling, drill collars used in this pipe. Beginning March 31st, 2015, owner shall file with the Division of Oil Gas Management a disclosure to specify the county in which the oil country tubular good initially used for the production operation after the date was manufactured, unless the country cannot be determined by the owner of the division. Prescribe the disclosure form. Consult with a representative of the natural oil, gas, oil, and steel industry to develop the form, and a division shall identify information specified in the form to establish quality well infrastructure catalog. See, the division shall determine the date of the disclosure form shall be filed. 1509-17, encasing wells. A well shall be constructed in the manner of the approval of the chief of the division, oil, gas, resource management, special of the permitted use of the material to comply with the industry standard for the type of the depth of the well, the anticipated fluid pressure will be associated within the well. The addition of the well shall be constructed in sufficient steel with the conductor casing with a manner with the support of the unconsolidated sediment to protect the isolate all of the underground sources of the drinking of the water, to define the Safe Drinking Water Act, that provides the basis for the blowout with the preventer of the other well with the control and equipment necessary for the control of the information pressure for the fluid drilling for the well, the operation complete with the well, using steel production casing with a sufficient cement oil gas reservoir shall be isolated during the well stimulation with the during the productive life of the well. In addition, start gas zones and gas bearing zones with a sufficient pressure of the allowing to overpressure of the surface of the production annulus, resulting in annular overpressurization. Isolate well shall be isolated using approved cement sanding, casing, and well construction practically isolating an oil gas reservoir shall not be excluding an open hole completion. Well shall not be perforated. The purpose of wells stimulation in any zones located under the casing protects the underground source of drinking water, whether without written authorization of the chief of the corners of the division D of this section. When the well penetrates the excavation of the mine, the casing should remain intact and provided in section 1509-18 of the revision code of the plug and been in accordance with 1509-15 of the revision of this code. Chief may adopt the rules in accordance with chapter 119 revised code and consistent with division A section of the established standard construction well, the evaluation of the quality of the well construction material, completing remedial cementing in addition with the change of the established rules under the considered local geological various drilling conditions shall require the use of reasonable method of the based on the sound of the engineering principles. See, an owner and owner authorized representative shall notify the oil gas resource inspector each time the owner and authorized representative notifies of the person to perform cementing with the conductor casing, the surface casing of the producing casing. In addition, within 60 days after the completing of the cementing of the production casing, owner shall submit with a chief copy of the cementing tickets for each cemented string of casing with a copy of the logs where used to evaluate the quality of the cement. Chief shall grant an exemption when the section rules adopted under the well with the chief determines if the cement bond logs confirm zonal isolation. This means that 500 feet between the most perforation of the casing and lowest depth of the underground source of the drinking water. 1509-18, well drilled within the limits of the mining operation. Person who would drill within the limits of the mining operation will be given the consideration safety of person working on the mine. If possible, shall look at the well if the penetrate of the piler. If the well is drilled to be drilled with the limits of the mining operation, penetrate with the excavation of the mine, a hole to produce approximately 15 feet above the roof of the mine, with the roof condition of the mine warm, with the hole should be produced with a rock formation immediately above the mining stringing with a casing placed on the shoulder. Shut off all the water drilling shall be continued with a point with approximately 30 feet below the floor of the mine. Another string of a casing set with both the string and casing approximately the same diameter with the diameter of the hole. If no water is encountered between the bottom of the dry pipes, approximately casing on the shoulder above the roof of the mine, and the move of the casing method the outline above, it is permissible to use the following casing method. The hole shall be drilled with 30 feet below the floor of the mine, and string of the casing shall be the extent of the surface of the point with 30 feet below the floor of the mine, and with a packer sufficient size attached to the string casing. The packer should be placed over it will then be below all of the water located with the rock formation immediately above the mine, and prevalent water destructive matter from the entering therein. The annular space above the packer between the casing and the well should be found within the pre-clayed minimum distance 50 feet. If the well is drilled within the limits of the mining operation does not penetrate with the excavation of the mine, the hole should be reduced 30 feet below the coal of the mineral is being mined, string casing placed at its point with the annular space of the behind when the casing should be filled with the cement with a casing seat with no point not less than 50 feet above the seam of the coal mineral that is being mined in the packer method outlined in the section also permissible in this type of the well. If it is permissible to attach release coupling or right-left nipple, the string casing will extend through the mine. The releasing of the coupling or the right-left nipple should be placed in such a manner that it is above the packer, at least 20 feet above the coal or mineral it is being mined. And well penetration and excavation of the mine, the casing should be enclosed, if possible, the column extended to the floor of the roof of the mine, built with a brick of the suitable material for the subject for the approval of the chief of the division, mineral resource management. If the chief finds with the methods prescribed in this section unsafe and inadequate and unsuitable, the chief requires the method to be altered in such a manner that it will be safe. 1509-181, suspension drilling opening well, coal-bearing townships. Chief of the Division, Mineral Resource of the Management may order immediate suspension from the drilling or reopening over the well, coal-bearing township, the determining of the drilling, reopening activity present with an imminent substantial threat for public health, safety, and miners' health and safety before issuing an order. Subdivision A of the section, Chief shall notify the Chief of the Division, Oil, Gas, Resource Management, the owner, and even there, the Chief of the Division, Mineral Resource Management that determines would provide reasonable notification. Chief of the intent to issue the subpoena order. However, the Chief may order the immediate suspension of the drilling and the reopening of the well, coal-bearing township without prior notification to the owner. If the Chief had made reasonable attempt to notify the owner, attempts to have them fail, the Chief of the orders immediate with the suspension of the drilling of the reopening, the Chief to provide the Chief of the Division, Oil, Gas, Resource Management, the owner notes for the order in such a practicable no later than 5 days after the issuance of the order. Division A, the section immediately suspend the drilling, reopening of the well in coal-bearing township. Chief of the Division, Mineral Resource Management shall provide the owner an opportunity to be heard. Present evidence that of the drilling and the reopening of the activity will not result imminent and substantial threat to the public safety of the mining owner's health and safety. Applicable, the Chief of the all evidence presented, the owner determines if the activity does not present such a threat, Chief shall revoke with a suspension order. D, notwithstanding the provision of the chapter, the owner may apply a suspension order on the issued under Section Reclamation Commission in accordance with Section 1513.13 of Revised Code. Well, stipulation, an owner who elects to stimulate with a well shall stimulate with a well in a manner with no endangered underground source of the drinking water no later than 24 hours of the commencing of the stimulation. The owner and operator authorized representative shall notify oil and gas resource inspector of the stimulation of the well, damage of the production casing of the cement occurs, result circulation of the fluids, annual for the surface production casing. The owner shall immediately terminate with the stimulation of the well and notify the Chief of the Division, Oil, Gas, Resource Management. If the Chief determines the casing of the cement with it may be remediated in a manner that isolate the oil gas bearing zones of the well, Chief may authorize the completion of the stimulation of the well. The Chief determines if the stimulation of the well resulted in irreparable damage to the well. The Chief shall order the well to be plugged and abandoned within 30 days of the issuance of the order. For the purpose of determining integrity of the remediation casing of the cement with the wells damaged during the stimulation of the well, the Chief, whoever the owner well with the cement, the evaluation logs, temperature surveys, pressure tests, and combination search logs and survey tests. 1509-20, preventing waste of the gas flaring. All owners, leasers, and their agents drilling and producing crude oil, natural gas should have every reasonable precaution in accordance with the must be approved of the methods of operating stop to prevent waste of the oil, gas, or both the productive natural gas quantity of sufficient justified utilization shall be utilized and shut off within 10 days after completion. Owner and any well produced in both oil and gas may burn such gas and flares as necessary to protect the health and safety of the public, and where the gas is lawfully produced, there is no economic market at well for the escaping gas. Alright, permits and secondary additional recovery operations. No person shall, without first obtaining with a permit over the Chief of the Division of the Oil and Gas Resource Management, conduct a secondary additional recovery operation, including underground interjection, fluid and carbon dioxide, secondary territorial recovery, oil and natural gas for the storage of the hydrocarbons liquid at a standard temperature and pressure, unless for the rule of Chief that expressly authorized such operation without a permit. The permit shall be the addition of any permit required in Section 1509.05 of the revised code. For the second additional recovery operation should be conducted in accordance with the rules of order of the Chief of the terms of the condition of the permit authorized such operation. Addition with the Chief of the authorized test of the evaluate with the fluid and carbon dioxide may be injected in a reservoir to determine the maximum allowable injection pressure. Test shall be conducted in accordance with the method prescribed in the rule of the Chief of the conditions of the permit. The rules adopted under this section and shall include the provision regarding application, the issuance of the permit, determine the conditions of the permit, entry of the conduct of the inspection, the examine the record of the certain completions of the section rules and orders and terms and conditions section. Permits adopt and issue thereunder. The provision and maintenance of the information through the monitoring, record keeping, and reporting other provision furtherance goals of the section. Safe Drinking Water Act. To implement the goals of Safe Drinking Water Act, chief shall not issue permit underground injection fluid, secondary territorial recovery oil with natural gas storage, hydrocarbon, liquid attaining temperature, pressure, unless chief concludes that the applicant has demonstrated that the injection will not result in the presence of any contamination underground water that supplies can be reasonably expected to supply any public water system such for the presence any such contaminant may result in the system non-complying with the national primary drinking water regulation, may otherwise adversely affect the health of of persons, or rules or term and conditions permits adaptive issued under the section shall be construed to be more stringent than required for compliance with the Safe Drinking Water Act, unless and essentially to ensure underground sources of drinking water will not be endangered. Storage and disposal of brine, crude oil, natural gas, and other fluids. And I guess this one's pretty long, so we're going to cut the tape there.